In this short video, we're going to be taking a look at the test for deceptive similarity and how it was applied in the case of Henschke and Rosemount Estates. We'll go through a brief overview of what that case was about, then what the law of deceptive similarity is and what the test is, and then finally we'll take a look at how the court applied it in Henschke and Rosemount. That case was about two wine producers and sellers. Henschke, the plaintiff, had been producing wine since 1958 under the name Hill of Grace. This type of wine was extremely expensive and still sells for over $1,000 a bottle. Rosemount Estates, the defendant, were also a wine producer, and in the few years before the case, they had acquired a winery, a vineyard, and then a trademark to produce wine under the name Hill of Gold, and the winery and the vineyard were also known as Hill of Gold. The issue was that Henschke thought that Rosemount were infringing on the Hill of Grace trademark by selling the Hill of Gold wine because it was deceptively similar to the Hill of Grace trademark. Deceptive similarity is covered in the Trademarks Act in sections 10 and 120. Section 120 is quite large and only subsection 1 is relevant to this case. That subsection states that a person infringes a registered trademark if the person uses as a trademark a sign that is substantially identical with, or deceptively similar to, the trademark in relation to goods or services in respect of which the trademark is registered. Now this is quite a mouthful, but section 10 is a bit clearer. It goes on to say that a trademark is taken to be deceptively similar to another trademark if it so nearly resembles that other trademark that it is likely to deceive or cause confusion. So a very obvious example with that would be if I started a chocolate company and sold chocolate called N&N's. Obviously, this is very similar to M&M's to the point that it would be deceptively similar and it could deceive and confuse. Now, this area of law is quite comprehensive, and the test for applying deceptive similarity can be a bit confusing. A more recent case, the Crazy Ron's Communication case, laid out an extremely clear and succinct summary of the test, and I'll just run through those 5 points before we take a look at what was done in Henschke and Rosemount. The first thing to know is that the test, unlike that for substantial identity, is not judged by a side-by-side comparison. It is a question of fact for the court to consider. Going on, it is necessary to show tangible danger of deception or confusion, and the court must make allowance for the imperfect recollection a person may have. Finally, the authorities recognize that the concept of imperfect recollection applies to trademarks other than those consisting of invented words. That means that a phrase, like Hill of Gold, can be deceptively similar. In the case of Henschke, the court focused on the importance of reputation. They began by distinguishing this matter from others. They said that while the wine was well known, it didn't have the same fame or notoriety such as brands such as, say, Coca-Cola or Woolworths, which were very well known. It then considered firstly whether the trademark, as Henschke were arguing, could stop all Hill of X wine names. So for example, Hill of Goanna. The court found that this would be casting too wide a net, and on this basis that Henschke could not stop all Hill of so-and-so wines. Finally, they considered the key question of whether Gold and Grace were so similar as to mislead or deceive. They said that while the words were phonetically similar, they were not deceptively so. The definition and the use of Gold and Grace were and are different to the extent that the names do not resemble each other so much as to deceive or cause confusion. On this basis, Rosemount won the case and were allowed to continue to produce and sell their wine.